the EU has set out, and Mr. Sims reiterated this position, that the contentious parts of the treaty would not be included in provisional application, would not take effect. But unless there is my opinion on this is unless there is a specific provision in the agreement for provisional effect that excludes them, then it's not up to Canada or the EU. It's up to the tribunal. Because an ICS tribunal, and I'll talk more about that in a moment, sir, an ICS tribunal has the right to make its own decision on jurisdiction. And this, an equivalent matter came up very recently, although it's still in the process of enforcement litigation. The substantive questions were decided in the UKOS and Russia case. And in that case, Russia made the argument that certain parts of the treaty were not included in provisional application. And the tribunal made its decision based on an agreement called the Vienna Convention on the Law of Treaties. And the Vienna Convention sets down how we must interpret these things. And the basic rule in that is known as a peremptory norm of international law, which means it is applicable to all states. It's called the Pattison Evander principle. And it means that when a treaty is applied, it must be applied in totum, completely, or not at all. So states don't have the choice to pick and choose which part of a treaty they want. Now, CETA has never been litigated. We don't know precisely what decision the tribunal will make, but what we do know is that it will be a decision for a tribunal, not for either the governments of either party. So the legal uncertainty about which parts of CETA will take effect remains. I want to turn to the point about the issues with the ICS mechanism, the investor court system, because I think it's important to tease those out. I'm grateful to Mr. Sims that I agree that this was a system put in place in response to criticisms of the investor-state dispute settlement system, which was the old system of arbitration. It's my opinion that it does not effectively respond to the problems that were raised with that system. And I'll give two reasons for that. The first is procedural. It doesn't respond to the procedural problems, although it creates a system of appeals because there is no doctrine of precedent in arbitration, because courts are not bound to follow the decisions of more senior courts or the decisions that courts have made in the past. The appeal system is in effect fairly irrelevant. What an appeals court does is it establishes a body of law, a body of jurisprudence that the lower courts, or in this case, the lower arbitration tribunals, then apply. If there's no doctrine of precedent, then what an appeal court establishes is far less relevant. And when there's no doctrine of precedent, it means that if you're advising a government or if you're advising an investor, when they say, what's the answer to this question? The best you can give is, well, I think this is the correct answer, but the tribunal, if it ever goes to a tribunal, the tribunal will be well within its rights to come to a completely different answer. So I can't give you a definite answer to that question, which makes it very difficult to legislate, but it also makes it difficult to invest, particularly if you're a small investor who's not going to have the money to benefit from this system. My second objection is a principled objection, and that is this creates two different sets of law, and it does so unnecessarily. Investors are able to have certainty in all European systems because we already have a senior court. We have senior courts domestically, our courts of appeal and our Supreme Courts. And we have a senior court for the European Union continentally, which is the Court of Justice. Now, the original advantage of these treaties was to provide legal certainty when there wasn't independent courts, when a government could influence the courts. Now, I hope we can all agree that governments in Europe don't influence their courts. So what you're actually doing, because you're no longer solving that problem, is you're creating a special set of law with preferential principles for investors that ordinary citizens don't have access to. And so I have a principal objection to that on rule of law grounds, that the principle so dear to this committee that all people should have access to the same law and the same law should apply to all. And I'll turn to the negative and positive lists issue. The difference between a negative and a positive list is, well, to begin with, to set context, they both relate to exclusions. They relate to the areas of public policy that a government can exclude from the ambit of the treaty. Now, with a positive list, governments set the areas that they want the treaty to cover. So, for example, as a government, you might say, right, well, I want this to cover health policy, and I want this to cover geographical indicators. I'm happy for those issues to be in the treaty. Anything else, if you haven't specifically put it into the treaty, it's not there, it's not covered, it's not within the ambit of the treaty. With a negative list, it works the other way around. So unless you specifically exclude an area of policy, it is covered within the ambit of the treaty. Which means we don't know the ultimate ambit of this treaty. Because new areas of policy in a democracy, and particularly in a considering that public policy evolves all the time, we don't know which areas will be included. For example, is the regulation of robots, for example, is going to be included? This is an area of public policy that has emerged in the last 10 years. We could not possibly have predicted that artificial intelligence would have been an area of public policy even 20 years ago. But under a negative list, those new areas, unanticipated areas, are automatically included in the treaty because they haven't and can't possibly be specifically excluded.
We heard the concerns about dispute settlement through Europe, and during the legal scrubbing of this agreement, we agreed to actually amend part of that agreement to allow people who are dissatisfied with this dispute settlement that doesn't exist, allow it to be included. There is now a chapter in there on dispute settlement set up in a way that allows you to go to court proceedings. That has been accepted by both sides. But here's the other part. That dispute settlement chapter must be ratified by the member states. So when it comes to competency, I see your point. Like the EU has the competency over the general materials, what you would call the low-hanging fruit, the things that are not contentious between two bodies. But the dispute settlement is. And I noticed in your presentation you have that there. But we are sympathetic to what many social democrats in the European Union have been saying, and we've been agreeing with a lot of it. We already have that mechanism, and it works. So when it comes to dispute settlement, it does come to a vote to the member states. So my question is, does that still not satisfy your objections to this dispute settlement mechanism, by which we think it's a good way to proceed? Thank you.
I'm a little bit scared for the food safety, because I think food safety system is totally different in US and in EU. The civil servants don't explore the food until those are final products in US, and in Europe we have very high standards and rules through the food chain. And in US it's enough if the food has not, if the food is not dangerous for the animals or for the people, in investigations made often by the company which owns the products. Okay, in the report, hormones, GM products, and the antibiotic growth promoters for the animals are mentioned. But I just think, should there be told more about this food safety? Should they mention that we could keep our food safety standard? For example, we can't use many herbicides and pesticides, which are very common in US.
We do not like to see deeper regulatory cooperation in areas where environmental and consumer policy could be weakened, and we are in favor of support of the highest environmental and health standards. This means that the precautionary principle must be in the text, not only mentioned, but it must be relevant for the whole TTIP and CETA agreement, and all the agreements must get full parliamentary approvals. You might know that between October 2014 and 2015, more than 3 million people signed a petition. 3 million people in mainly all 28 member states of the European Union signed a petition against TTIP and CETA. Under this background, the TTIP leaks happens. This is the German parliament. In the morning of the 2nd of May, on the 2nd of May, my colleagues in Greenpeace Netherlands released 248 pages of so-called secret documents which have been called consolidated text of the negotiation between Europe and the United States. And you know that the European Union has published the documents coming from the European Union, but never the American side has published any proposal for the negotiations. Therefore, what we have done and what was new was to publish 13 chapters which include the vision, the proposals, and the ideas of the American United States. So this is a list of the chapters we have published, and our analysis of these 16 documents was we have identified four main, sorry, there's a mistake in the beginning of the slide, should be the number four main threats for the environment. And also we have been a little bit shocked to see that the state of the document was very low. So they are called consolidated texts, but they are not consolidated in our view. Our main concern is the silent death of the precautionary principle. You all know that the precautionary principle is a leading principle in Europe for the protection of consumers and for the environment. And in these 13 chapters we have analyzed, there was nothing regarding the precautionary principle. It was not mentioned as a word. It was also not mentioned with the meaning of the precautionary principle. The second one, also shocking, is after Paris, after the climate agreement of Paris, we would think that any new free trade agreement should include a reference to Paris. But again, nothing was in this document showing that there is support for the Paris Agreement. And also, a normal issue in trade agreements is that there is a general exception clause, which is based on GATT 20, the exception clause in the GATT agreement of the World Trade Organization. Also, this exception clause, which could allow to stop trade if there is the protection of human, animals, and plant life or health not secured. Also, this exception clause was not in the chapters we have analyzed. But what we can see is there's no environmental protection in the text we looked on, but there's a door opening for the business, giving business the opportunity to be part of this regulatory bodies in the free trade agreements, which have been just mentioned by my colleague.